Okay, welcome back. And we are ready for our last panel of the day, and it is a great panel. It's on FCPA trends and developments. And first, let me introduce our moderator, Lorraine Echavarria. Lori is a former SEC enforcement staffer of 15 years when she was Associate Regional Director and Head of the Enforcement Program for the LA Regional Office. She was also an Assistant Director at the SEC for more than 5 years and served on the Municipal Securities and Public Pension Specialized Unit in the Enforcement Division for 2 years. Now she's a partner in the Securities Litigation and Enforcement practice at WilmerHale, representing public companies, corporate officers, financial institutions, hedge funds, and all the different types of market participants facing government investigations and enforcement actions. Lori, it's great to see you again and welcome.
Thanks, Bruce. Glad to be here.
Let me next introduce Melinda Haag. Very pleased to introduce Melinda. I checked. The last time I saw Melinda, she was giving the keynote speech at Securities Enforcement Forum West 2015 in the Four Seasons, which was fantastic, by the way. At the time, she was the U.S. Attorney for the Northern District of California, a position she held for 5 years. Previously, she served for 9 years as a federal prosecutor, ultimately being tapped by then U.S. Attorney Robert Mueller as chief of the white-collar section of the San Francisco office. It is fantastic to have Melinda with us today to take a look at the FCPA. Welcome, Melinda.
Thank you, Bruce. Nice to be here.
Next up is Tom Heck, partner in KPMG's forensic practice. Tom has over 16 years of experience assisting clients with a wide range of forensic investigative services, including fraud risk assessments, anti-bribery and corruption services, financial reporting and securities investigations, due diligence, fraud investigations, and much more. It's great to have Tom with us to get the consulting perspective on the FCPA. Welcome, Tom.
Thanks, Bruce. Look forward to talking about FCPA.
And finally, very fortunate to have Kevin O'Connor with us. Kevin is Vice President and Chief Legal Officer for Carrier, where FCPA compliance is a big part of his responsibilities. Kevin and I were in the Division of Enforcement together back in the 90s. Since that time, his career path has been quite interesting to follow. Along the way to Carrier, Kevin was appointed as U.S. Attorney for Connecticut, later became Associate Attorney General of the United States, the third ranking official at the DOJ. Next time I caught up with him, he was Chief Legal Officer for Point 72, and now he's with Carrier. So Kevin, it's fantastic to see you again, and welcome, and look forward to hearing your perspective on the FCPA today.
Thanks, Bruce. Appreciate it.
Thanks. Lori?
Thank you. Thanks for the introduction, and welcome to everyone, and thanks to the panel and everyone who is attending on the last panel of the day. We'll make our way through this fairly quickly so we can release everyone promptly on time. But we are very happy to talk about the FCPA with this group of experts. As we'll discuss, I think one of the things that's interesting about the FCPA is that it is an apolitical area of enforcement. It has remained constant and steady for several different administrations. And we'll talk about the fact that we don't see that changing in this administration. We do think that FCPA enforcement will continue to be robust and going forward time. So this afternoon, we'll basically cover the year in review, what happened in 2020 with the FCPA, the new administration, recent legal developments and litigation outcomes for both the SEC and DOJ. And then we'll do a grab bag at the end, time permitting, that'll include a touch on whistleblowers, collateral litigation, and maybe other priorities that impact the FCPA. So to set the stage for our discussion, in 2020, there was a modest decline in the overall number of FCPA matters. It basically went from 65 in 2019 to 40 in 2020. So not a huge decline, but somewhat of a decline. And that said, 2020 was still a record-breaking year in terms of penalties, even given this decrease in the number of enforcement actions. There were $6.4 billion in total penalties brought in 2020. Two of actions, the Airbus action and the Goldman Sachs action, constituted 84% of that amount. And Melinda will talk a little bit about those, I'm sure, along the way today. So I wanted to start with hearing from Kevin and Thomas about the impact of the COVID-19 pandemic on corporate compliance programs and anti-corruption programs at public companies and in internal investigations especially as it impacts the FCPA and the international kind of overlay, and then we'll go from there. So Kevin, what did you see in this past year in terms of the corporate compliance program at Carrier and how it functioned?
Yeah, I would say two high-level observations. I think the first was, like everybody can appreciate, your ability to do internal investigations the way we're used to it, jumping on a plane, interviewing witnesses on site, wherever on site might be, anywhere across the world. That obviously changed. So I think we all had to kind of figure out a way not just to do our reactive investigations remotely and the challenges that poses, but also the audits that most organizations do. The kind of kick the tires audits had to be done remotely as well. I think we adapted to that as well as everybody else has, whether you're taking depositions or making oral arguments by Zoom. It's not ideal, but you can make it work. I think, though, perhaps the most noticeable difference since the pandemic is the significant decline in the number of internal allegations of wrongdoing that we receive. And when I say wrongdoing, I don't just mean FCPA. Fortunately, we don't get that many FCPA type allegations, but all sorts of allegations of employee theft, allegations of bullying, allegations of, other misconduct. When everybody went and worked remotely, I guess it shouldn't be surprising, but the number of internal complaints, whether to the hotline or to our ethics and compliance officers, to HR and to legal, has really dropped precipitously. And I can only ascertain that has probably led to a bit of a slowdown in self-reporting. Because if we're not getting those internal allegations, and an allegation of misconduct that has nothing to do with the FCPA, when you pull back a few layers, could in fact be an FCPA violation. We're not seeing a lot of that. I suspect as people come back to work, they'll observe a lot more, and that'll pick up again. But that's probably been the most noticeable observation from our perspective. And when I talk to my colleagues that are in-house, I think they're seeing the same thing. The ethics hotline's not ringing as much. HR is not getting as many calls. Compliance isn't getting as many internal allegations of suspected wrongdoing. And that has probably led to fewer and fewer self-reports being made to regulatory authorities.
That's very interesting. It is, I guess it does make sense if you think about the fact that people aren't able to be side by side and working side by side, so they don't engage in interactions that cause complaints or observe interactions that cause complaints. So in that sense, it does follow from remote work. But I don't know that it was anticipatable, like so many things that have come out of this odd year. Thomas, have you seen any impacts on internal investigations that flow from the trends that Kevin's talking about or otherwise in terms of the reports of fraud or the depth of internal investigations that have been going on?
Yeah, absolutely. And I think, just to piggyback a little bit off what Kevin was saying, the virtual workplace has changed a lot of things. I mean, just to kind of think about it a little bit, it's changed the fraud triangle. There's different pressures, there's different opportunities, there's different rationalizations that maybe existed pre-COVID and changed significantly once we entered, this virtual world that we all, unfortunately or fortunately for some of us, I think I've heard some of the panelists mention today, they don't mind, particularly the SEC folks don't mind the virtual world and doing the virtual depositions and stuff. I know I miss the daily interaction mostly with people the most, but looking at the ACFE has done a number of surveys since the inception of COVID. But one they did in November 2020, particularly, 79% of respondents indicated seeing an increase in fraud since we've gone virtual. And specifically as it relates to bribery and corruption, 70% of the respondents indicated they would expect to see an increase in the near future in fraud as it relates to bribery and corruption. So it's interesting as Kevin's experiencing, the hotline's dead, the folks maybe reporting peers or other wrongdoing, misconduct that they see is not coming through. So it'd be interesting to see, what the next 6 months to 12 months brings. If those respondents are seeing that fraud and for some reason not reporting it, is that going to come through and create a wave of work for us? I think ultimately, as an important thing for all public companies or any companies that are subject to maybe FCPA regulation need to look at is the compliance programs need to be reevaluated and adapted for the work from home environment. I mean, you got to look at the design of your program. Is it designed well and will it work in the work from home environment? I mean, I just think of FCPA programs pre-COVID and, we're focused on entertainment, the gift policy, meals, that kind of stuff. I mean, in the virtual environment, that stuff's all pretty much gone. So as you look to code of conduct at a lot of these, large companies, that's what's in the code of conduct. So does that code of conduct have to be refreshed? Does it have to be updated to reflect maybe how are you interacting with your third parties and your customers now in the virtual environment? And then, is your program adequately resourced and in the right way for a virtual environment? And then lastly, will it actually work in a virtual environment? I think those are all, very important things you have to think about. And, just to echo a little bit of what Kevin said from the investigation standpoint of view, I mean, I have a big Fortune 500 pharmaceutical client, and, they had an investigation come up and she said to me, usually I just get on a plane and get to the bottom of this, figure out what's going on, do some interviews, pull some accounting documentation. Now we're not able to do that anymore. So it changes completely the way you go about conducting investigations and your findings and access to evidence and things like that.
It is interesting to the point about the code of conduct needing to maybe reflect some of the new realities of this, even though it is a time period in flux and in change where no one anticipated going to this environment, and we anticipate leaving it behind, hopefully by the end of this year, optimistically maybe. And so, it'll be interesting to note whether the codes of conduct at companies were elastic enough to kind of, cover that change and come back and do what they needed to do. And I do think that we kind of anticipate also that there will be an uptick in reporting and self-reporting maybe next year or the following as people come back to working non-remotely in the office or at the field or at manufacturing facilities or whatever, and start to make complaints again or identify problematic conduct again. So let's now switch to talking a little bit about what the DOJ did in 2020 and some of the initiatives that it undertook, even given the challenges of COVID. And Melinda, I know that there were some notable developments at the department in the FCPA space this past year. What were those?
There were. I'll tick through the list of them, hopefully quickly. I think the bottom line, it seems to me, is that DOJ took the opportunity, maybe the pandemic break opportunity or pandemic slowdown opportunity, to get their house in order on a few things. So one thing they did in the summer of 2020 is DOJ and SEC jointly released an updated FCPA resource guide. It was originally released in 2012 in the Obama administration, and they jointly released an update. It didn't really break a lot of new ground, frankly, but it updated legal and policy developments that had taken place in the preceding 8 years. So it was probably time to do that. They also took the opportunity, again, they may have had a little time on their hands, to update their guidance regarding the evaluation of corporate compliance programs. Again, it didn't really break new ground. They did get a little bit more granular in advising prosecutors on how to look at compliance programs, for telling prosecutors, here's the question you should ask, and not this other more general question. So again, just got more granular. And so it can be helpful for people to review that if you're sort of in that world on behalf of your own company or on behalf of a client. One sort of notable update in the guidance was to address the Second Circuit's decision in 2018 in U.S. versus Hoskins, which we're going to talk about later when we talk about case developments. But that was a pretty notable decision that limited the FCPA's extraterritorial jurisdiction over foreign nationals. The earlier guidance in 2012, very notably, had this very aggressive view of extraterritorial jurisdiction. I actually remember reading it at the time and thinking, that's pretty aggressive. DOJ's view of extraterritorial jurisdiction, and DOJ got its hands slapped a little bit by the Second Circuit in Hoskins. So they actually updated the guidance to reflect the Second Circuit's decision in 2020 in the 2020 updates. The 2020 resource guide is interesting in that it notes the growing number of agencies that are involved in FCPA investigations, which wasn't the case before. CFTC is involved, the Federal Reserve, the Treasury Department's Office of Foreign Assets Control, and FinCEN, all involved. I think all wanted to be part of the party. And the resource guide acknowledges that involvement. CFTC, as part of its entry into this, released its own guidance in October of 2020 with respect to FCPA, really parrots DOJ and SEC guidance, but they, again, sort of probably want a seat at the table and release their own guidance. Another thing that DOJ did in 2020 is they created a special matters unit within the fraud section, and it focuses on, it's a separate group of people and prosecutors, and they actually hired directly into it in 2020 to focus on privilege and evidence collection issues in 3 subject matter areas: FCPA, healthcare, and securities fraud. And the reason they did it is probably in response to a few things. One is there was great criticism of the use of taint teams in conducting initial document review when there are privilege claims and other confidentiality issues. It's basically prosecutors tapping their friends down the hall and asking them to be the taint team and to review discovery and to only release to the prosecution team appropriate materials. But the reality is they're your friends down the hall. There was a case in Florida that came out relatively recently that was very critical of the use of the taint team in that particular case. There was also the search of Michael Cohen's office most recently, and there was a big dispute in that case about who would be able to review his materials. He was obviously counsel to the president, a lot of sensitivity, and ultimately they decided not to use a taint team and to ask the court to appoint an independent special master. And then there was a Fourth Circuit opinion also in the intervening time that was very critical of DOJ in connection with a privilege dispute involving Walmart. DOJ had made a lot of promises in writing to Walmart about how it would handle the offer of what would be privileged information. For example, they interviewed the general counsel of a subsidiary of Walmart, all kinds of promises in writing about how that would be handled. And then DOJ turned around and subpoenaed that GC of the subsidiary to appear in front of the grand jury and provide the same information. There was a big brouhaha over that, needless to say, and the Fourth Circuit issued an opinion that was not complimentary of DOJ. So all those things probably led to the creation of this unit. It remains to be seen how it plays out. It's pretty new. 2 other quick points. In 2020, DOJ issued its first FCPA opinion in 6 years, and they ultimately advised that the proposed payment would not trigger an enforcement action. Probably was expected by the party that asked for the opinion. It took 9 months to issue that opinion. So what that probably means is that it's not going to be seen as a very fruitful avenue for people to get quick answers on FCPA questions. And finally, DOJ announced a China initiative in 2018, which included a focus on cases involving the FCPA and China. There was 1 FCPA case announced in 2019. There were none announced in 2020. So a lot of cases announced related to the China initiative, but only 1 in the 2 years regarding China. So those are kind of the non-case related, non-enforcement action related developments. Again, just sort of a lot of putting their house in order.
Yes, and it does sound like that, and we'll come back to talking about some of the litigation developments in a moment. I think first we wanted to touch on the new administration. I know I said at the beginning that this is an apolitical area, and I think that it is, and I think that's consistent with what we'll see. But there are going to, things evolve. FCPA enforcement will evolve, as Melinda's been talking about. DOJ has learned from prior mistakes, prior, bad court rulings, and is making adjustments accordingly. So we'll talking about the changes coming in 2021. Obviously, with the SEC, there's, as it's been discussed and as known, there's a new chairman in place. and we are awaiting the appointment of a new enforcement director. I think that will give a lot more guidance on the specific direction the agency is going to follow once the new enforcement director is named. But we do anticipate little change in FCPA enforcement other than more of it. I think we do expect to see that there will be a continued focus in bringing these matters to fruition, and consistent with Chairman Gensler's comments and with some of the observed results of his tenure at the CFTC, I think we expect to see things moving more quickly, that there will be an approach and a focus on bringing investigations to a head just more quickly and with shorter deadlines and things like that. So I think that's sort of what we expect so far based on what we know at the SEC side. What's on the horizon for the Department of Justice in 2021?
So I think you would expect to see a lot of consistency between the Biden and Obama administrations at DOJ. It's pretty obvious. There are a lot of people that have been nominated or confirmed for positions in DOJ that were in the Obama DOJ. Lisa Monaco, who is the Deputy Attorney General, was the head of the National Security Division. Vanita Gupta was the head of the Civil Rights Division under Obama. Ken Polite, who has been nominated to be the AAG of the Criminal Division, was the U.S. Attorney in New Orleans in the Obama administration. So a lot of the same people are coming back. Great people, by the way. So you would expect a lot of consistency. The current acting heads of the components that relate to FCPA, Criminal Division, the Fraud Section, and the FCPA unit are all people that served in the Obama administration, either in the White House counsel's office or in the Fraud Section, and specifically in the FCPA unit. So everything is currently being run by people that were in the Obama administration. So again, I think you're going to see a lot of consistency. And with respect to FCPA, certainly President Biden during the campaign talked a lot about fighting corruption in the U.S. and abroad. And Merrick Garland is somebody who has deep experience with corruption and white collar matters. So again, just really expect a focus on having an enforcement environment, specifically in the white collar area, and then FCPA as well. So just really a lot of consistency. One thing, and as Laura, you noted, with respect to FCPA, there's a lot of consistency between administrations, regardless of party, over time. So we didn't see a huge drop off in FCPA enforcement, obviously, during the Trump administration. One thing that did change, though, was the use of monitors. The Trump administration didn't seem to favor the use of monitors, and the numbers of monitors fell off quite precipitously. None were appointed in 2020. 10 were appointed in 2016, and in the intervening years, 1, 2, and 4. So there was a pretty precipitous drop off. So I think we would expect to see a return to the use of monitors. And so that may be one difference. I'll pause there. I think those are sort of the key issues.
Great. Thank you. And then I think we're going to kind of shift the focus a little bit and ask Kevin to tell us about what he sees on the public company front. And this may be not related to FCPA. It may be other trends that are impacting public companies. But since we're lucky to have you on the panel, we thought we'd take advantage of the opportunity to hear what's coming, what you see coming down the pipeline this year.
Well, I must say, I think that's right. I don't see anything earth shattering on the FCPA front, but I must say, having worked with good monitors, it does send a little bit of a chill down my spine to hear that monitors are coming back. Now, and I say that with all due respect to monitors, and I see the value they bring, but it became sort of a stock and trade. And I think a lot of companies, whether you were in-house or representing the company, the monitor was always a throw-in at the last minute to a settlement. But if you think about what's going to happen after a settlement, the amount of time and money you still have to spend internally at a company on a monitor is not to be underestimated. It's millions of dollars in legal fees that you cannot control for the most part. Because they're not your outside counsel where you can say, hey, come on, I don't want you to do that. They have free reign as it's designed to be. But the other thing is that I didn't appreciate till I had a monitor when I was general counsel is I had to hire 2 lawyers internally just to respond to the monitor's requests. And honestly, I didn't know that when I settled the case. I did not give enough thought to what it meant to have a monitor, but having a monitor is having a prosecutor, not a prosecutor who wants to send you to jail, but they're constantly asking to interview witnesses, examine documents. It's their job. And that's, I don't say that critically, it's a fact, but it's having a roving ombudsman living with you, and you're paying their bills, and they're expecting, understandably so, you to get them all the information they need. So it's almost like a continuation of the same investigation you thought you settled, but now you can't, it's interesting. I don't know, man, we talk in the in-house community. Has anyone ever hired outside counsel to manage their monitor? Because you really do need lawyers, not to manage the monitor, to manipulate the monitor, just simply to respond to all of the requests for information. And I certainly underestimated it at 0.72. And we had a great monitor. They did a great job. And I wouldn't have a critical word to utter about them. I did underestimate just how much work is involved in that. I think a lot of companies do. But I do think there's a time and a place for monitors. I do think for a time it got a little bit sort of matter of fact. Every case had a monitor. And there was some criticism of the revolving door of AUSAs and US attorneys going out and getting monitorships. And so I think the fact that they've scaled it back a little bit was a good thing. Eliminating it, maybe not, but scaling it back, I would generally be in favor of on that front. I think, Laura, the only other thing I would say in terms of enforcement that we watch as a public company quite closely is what role the SEC in particular is going to play on ESG disclosures. We are under tremendous pressure from our investors, our institutional investors, not the SEC or the regulators, but our investors to share information about our long-term sustainability goals. And I must say, I look at what some of these companies are saying about their goals, and they're very, very bold and ambitious, but they're also 15 years away. And I think to myself, well, gosh, I could agree to do something by 2050 because I'm not going to be the one to answer questions 30 years from now if we fail. And I think the SEC is probably going to be looking pretty hard at the promises that public companies are making to pacify investors and whether or not they're accurate, whether or not they're feasible. And I think they're going to have to create standards because I don't know how you can demonstrate that someone makes a misleading statement when they say they're going to do something by 2050. I don't know how you could demonstrate that that's a material misstatement. But I think a lot of people are making statements they know investors want to hear, recognizing they're not going to be the ones that ultimately have to explain in 30 years whether or not we accomplish those goals, and maybe hoping people will forget we even made those promises by then. So I think the ESG arena is probably an opportunity for the Biden administration to really set some precedent here that could have a real impact on companies like ours.
I think that's an interesting observation too, because I agree. I think one of the things that the SEC enforcement side has been saying, to the extent they're saying much about it, is that they're going to rely on historic, SEC cases and principles to look at these cases, and that would require proving material misrepresentations or omissions, and that is difficult when it comes to statements of predicting the future that has not yet come to pass, that are appeasing investors today. So that's exactly right. Investor today, maybe, yes, possibly. But can you prove that it's false? Not today necessarily. So that's going to be a very interesting problem to solve. And I think you hit the nail on the head saying there's going to need to be some kind of insert of principle, a new, change to bring enforcement into that dialogue, because it really isn't going to fit an enforcement, universe perfectly.
Yeah. Hey, Lori, can I add one thing about monitors? A little ray of sunshine. I get it, Kevin, and I will tell you, when I was the U.S. attorney, we were hearing from chief legal officers and GCs and their counsel about the impact of monitors, and I think the department was starting to listen. And there was a 1-year pilot program that was put into place in April of 2016, so still in the Obama administration. And it was designed to encourage self-disclosure and cooperation. It was a checklist of what companies needed to do. And it provided that if those standards were met, there would be a 25 to 50% reduction in fines and potential relief from monitors, among other things. So there was a recognition. And then during that one-year pilot, there were 2 cases that were declined, and 1 case that there was a non-prosecution agreement. So there were some successes from the defense side and from the justice side as well during that time. But then the Trump administration really expanded that and put it in the Justice Manual, which is always the way to make sure that it lives beyond administration. So now in the Justice Manual, there's the FCPA corporate enforcement policy, and it takes it a step further and says if the company meets these standards, there's a presumption that the company will receive a declination and that there won't be a monitor. So it will be interesting to see what the Biden administration does with that. I think they were headed in that direction anyway. And so it'll be interesting to see if they embrace the current version of the policy in the Justice Manual or if they try to dial it back.
Yeah.
That is interesting. And I think one thing we also wanted to talk about a little bit for 2021 is the impact, is what we see coming down the pipeline in terms of approaching internal investigations as people return to work. We already talked a little bit about we think there will be an uptick in complaints, but do you see continuing impact on corporate compliance programs or willingness to conduct large scale international investigations across the world, going forward for the remainder of the year? I'm looking to Thomas.
All right. Yeah, I mean, I think, the investigative landscape has been interesting. I know for us here at KPMG, conducting international investigations we've placed a lot more reliance on our member firms. So, those boots on the ground, if we do need people to conduct interviews or go get evidence, we have the ability to do that. But, I think the fundamentals of an investigation remain unchanged, right? The what, the when, the where, the how, the who, and the why. They're all questions that have to be answered, and they have to be answered by, getting evidence and conducting interviews. It's just whether you do those virtually or whether you do them in person, and what's the difference in the effectiveness of it, right? I know recently I had a client that we started a conflict of interest investigation over in India, and it quickly morphed into actually an ABC matter, an anti-bribery corruption matter. And we just have a lack of access to evidence. They never had an instance of SAP for the Indian, operation in the U.S. And it took us 4 months to get access in the back end to the books and records and be able to actually look at some stuff. So, I think if we get to return to travel and international travel, I mean, some of these hotbed areas of FCPA, by the way, if you look at the global map, I don't know that we're, I personally, I don't think my firm would let me go to India anytime soon with the current state of affairs over there with COVID. So, a lot of the red areas of the map are not places that folks are going to be traveling to anytime soon. So, I think it's this virtual alternative world of investigations, using our member firms, relying on our member firms, and not, necessarily going internationally, getting on that plane and doing those interviews yourself is something that's become the new norm for us. And it's become a great spot to be in the marketplace because we can offer those people to our clients.
Great. Okay, so we'll move a little bit now, shifting to litigation outcomes. I'll touch briefly on just on the statute of limitations and disgorgement questions in the SEC space, which is obviously, I'm sure people have heard about the Liu versus SEC decision. It's been discussed already, but in June 2020, the Supreme Court issued a decision in Liu versus SEC, which was closely watched to see if the Supreme Court would limit the SEC's power to seek disgorgement. And ultimately, the question before the court was whether the SEC could seek disgorgement as equitable relief, despite the Kokesh's prior ruling that disgorgement may constitute a penalty for purposes of statute of limitations analysis. The case did not involve an FCPA issue or violation, but it does have an impact. The findings and the holdings impact all of the SEC matters. And ultimately, the court, of course, did uphold the SEC's power to obtain disgorgement in civil actions, but they set some limitations that could have some interesting impacts on FCPA resolutions and settlements with the SEC going forward. They said disgorgement must be returned to victims and investors for their benefit. Disgorgement must deduct legitimate business expenses and cannot exceed defendants' gains, and there cannot be joint and several disgorgement against multiple defendants. And so this does raise a question in FCPA, settlements specifically, of how the SEC is going to think about disgorgement and whether it will change at all, because SEC disgorgement analysis has historically looked at whether at trying to collect the amount that was the benefit to the company of the bargain of the bribe, if you will. So what did the company get for the violative conduct? And they try to collect that profit, that income to the company. And they have not historically thought of it as purely profit. They've thought of it as the contract value. Sometimes that can be a lot of money. And so will there be some deduction now for legitimate business expenses that the company incurred in operating the contract? And will we go to more of a net profits analysis going forward in disgorgement settlements, which sometimes is a process has been arrived at through negotiation, but not always. So that'll be one question. The other question will be setting up more fair funds for disgorgement amounts in FCPA cases. And then second, there has been a statutory change at the beginning of this year to change the statute of limitations for disgorgement to allow the commission to obtain disgorgement within 5 years for most violations, but 10 years for scienter-based violations. And this raises an interesting and somewhat unresolved question under the FCPA as to whether 30A, the bribery statute, is a scienter-based violation. It does require corrupt intent. It does have prongs of well-knowing that there's a thing of value being directed to a foreign official. So there is language of intent and scienter in the statute, but it isn't traditionally thought of as a scienter-based statute. It wasn't one of the statutes considered or discussed in the legislative history. And so it'll be interesting to see how that, whether there's a 10-year statute of limitations that is attempted to be applied to 30A matters. And more to follow on that. And so I know also the Department of Justice had a lot of activity in resolutions this past year and some appellate activity that is notable. So I'll turn it over to Melinda to tell us about those developments.
Sure, and I'm going to keep it short because I can see the clock here. So as Lori noted, the combined FCPA U.S. corporate penalties in 2020 were approximately or a little over $6 billion. That was equal to 2016 and significantly larger than the years in between. So it was a big year in that way, but it was largely the result of two cases, as Lori also mentioned. Airbus was one of them. Airbus agreed to pay combined penalties of about $4 billion as part of a global resolution with the US, the UK, and France. And that case involved executives paying bribes to consultants and Chinese government officials in connection with the orders of civilian aircraft. There were no individual prosecutions and there was no monitor in that case, despite the sort of financial impact of it. The other sort of big case, blockbuster case in 2020 involved Goldman Sachs and its Malaysian subsidiary, and they agreed to pay about $2.9 billion, again, as part of a coordinated resolution with the US and Malaysia, UK, Singapore, and Hong Kong, if I remember correctly. It was part of this big sprawling investigation that got so much attention of the Malaysian Sovereign Wealth Fund, 1MDB. Goldman Sachs in the US entered into a DPA, and the Malaysian sub pleaded guilty to a one-count criminal information. Two individuals were criminally charged, one from each entity. One of them pled guilty and the other is facing trial. I think it was set for March of 2021, but it's been postponed to the summer. No monitor was imposed in connection with that case. Just one or two other notable cases. One is Vital, if I'm pronouncing it correctly. It's the US affiliate of a Geneva-based company. And it's just notable because it was the first coordinated action between DOJ and the CFTC. the company entered into a DPA, agreed to a $135 million criminal penalty, and they paid a $12.7 million disgorgement amount to the CFTC. So again, just showing the coordination continues among agencies. And then the big case is U.S. versus Hoskins, as I've already mentioned. It's very complicated. I cannot do it justice in the time that we have here. I'll give a little shout out to my law firm, Paul Weiss. You could go to the website. It's been described in detail in our firm's year in review, 2020 year in review, and also in some client alerts, and they're all online. It's interesting, and I'll just try to give you the very quick version. It's a pretty scathing Second Circuit decision for the government that puts limits on DOJ's expansive view of its jurisdiction, as I mentioned. And so Hoskins was a UK citizen. He worked for Alstom, a French company's UK subsidiary. He allegedly engaged in an FCPA conspiracy with people in Alstom, US. So from the UK, he had phone calls, emails with people at Alstom, US, and he arranged for payments. And they were all charged with FCPA violations. The government's theory of prosecution for Hoskins in the UK was that he was involved in a conspiracy and aiding and abetting, and that's what provided them with the jurisdiction. In a pretrial motion to dismiss, the court threw that out. And so the government no longer had a conspiracy and aiding and abetting theory. I'll skip over why, for the details, you'll need to read more about the case. But then the case went to trial on a different theory, which is that he was acting as an agent of Alstom US. The jury actually convicted him, and then the court, on a Rule 29 post-trial motion, actually reversed that and found that there was no evidence that he had a principal agency relationship with Alstom US. So quite a journey for Mr. Hoskins, but at the end of the day, his FCPA convictions were thrown out after the jury found him guilty. The decision is pretty scathing for the government, the Second Circuit opinion. So you should read it. I will, again, refrain from quoting it, but it's pretty scathing. And again, it led the government to have to go into its resource guide and to change that expansive view of their jurisdiction over foreign persons in the FCPA context. So it's an interesting read. And so if you're interested, I would definitely recommend that you read about the case, and you can certainly go to the Paul Weiss website. The father of modern FCPA enforcement, Mark Mendelson, is one of my new partners at Paul Weiss, and they do an amazing job. So I'll recommend that to you. And I will pause there. Those are kind of the biggies for 2020.
All right. And so we just have a couple of minutes, but to wrap up the panel and in the theme of some of the other discussions during the day, are there overlaps in the priority areas that the SEC appears to be interested in focusing on with FCPA enforcement, such as with SPACs? And I know there's been a lot of discussion about SPACs throughout the day, so it seems fitting to close with a question about whether that those entities will dovetail with FCPA enforcement. Thomas.
Yeah, and thanks for that, Lori. I know Aaron and Michelle on the directors panel, they mentioned, just the amount of activity and money in the SPAC market right now, or in the SPAC activities is through the roof. It's obviously going to, get the attention of the regulators, the SEC, the DOJ, anyone else that maybe has a hand in it. But, a lot of what we're seeing with the SPAC transactions is it's in a vacuum. It's happening so fast. And, these companies, as they go public, don't have, mature compliance programs, particularly around FCPA risk if they do international operations. So I'm interested to see, down the road, 2-3 years from now, just the amount of activity that we have in FCPA enforcement as it relates to SPAC transactions, because a lot of these things are happening very quick and they don't have the time to implement an adequate FCPA compliance program. But I see Bruce, so I'm gonna, and I know all that stands between the bar and everyone else, or I guess the virtual bar is me. So,
and all I'll say is, I guess that's a sign to watch the space, right, and see how new companies that came out of a SPAC transaction and are now in the public markets, how their compliance programs hold up going forward. So with that, thank you so much. Thanks to everyone on the panel. I really appreciate everyone's time, and thank you to everyone who connected with us today, and we're happy to have spoken. Thanks, Bruce.
Thank you, Lori. Great job. Tom, Kevin, Melinda, thank you so much for joining us today and being the anchor leg of what was a terrific day. That is a wrap. That's our last panel. So let me just quickly thank the 22 world-class consulting and law firms that were sponsors here today, supporters and participants. Really appreciate it. And thank you again to all the panelists and to every one of you for tuning in and being with us here today. We really appreciate it, and we hope to see you soon. Thank you.